One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the legal hour. Actus nemini facit injuria, the act of the law does no one wrong but uphold justice. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the legal hour. Actus nemini facit injuria, the act of the law does no one wrong but uphold justice. Hello viewers and welcome to the Legal Hour show here on Freetown Television Network, Channel 35 with me, Bakarr Marrah. And if you've been one of our glued viewers, I believe by now you must have now know that this is a show that tries to unravel the difficulties and the misconceptions about the law and about your rights, both civic and political. And if these rights are in any possible ways they could be violated, we give you tips that you will take that would be in the confines of the law. So this is the Legal Hour, and for this episode I am much more honored to have with me Mr. Rashid Dumbuya ESQ, who is a lecturer of the Bakarr College Law Department and also the Chief Executive Officer of Legal Link. Good evening and welcome to Legal Hour.
Thanks for having me. I'm grateful and happy to be here. It's my first time. I'm so happy to be at FTN.
Thank you very much, and we are so honored to have you in our studio today. And today we're gonna have a wonderful episode, and thus I have with me Mr. Rashid Dumbuya, who is the head of Legal Link and is also a lawyer. And our topic of discussion is the world of law. Yes, of course, the world of law is very diversified into different ways. How can you be a lawyer? What is law, criminal law, everything so far you want to know about law? Today it can be unraveled to you. So just take note as we are going to give you the basic prerequisite knowledge about the world of law. But as usual, we always have first our legal news before we get into our discussion. Believe me, just take note, because today gonna be extremely wonderful for you to actually get yourself into the world of law. Even though you're not yet a lawyer, you might be a law student or you might be just a common man, but yet this topic will get you interested into the field of law. But let's have first our legal news, in which for this episode it revolves around one of the recent activities of the SEC. The SEC was successful in handing over a stolen Land Cruiser Jeep to the Minister of Transport. Let's just take a look and then get back to our discussion. This is the legal page of the Legal Hour TV show, and for this episode we are looking at one of the headlines of the set. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the legal hour. Actus nemini facit injuria, the act of the law does no one wrong but uphold justice. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means Ignorance of the law is no excuse. Some of us do appreciate such legal expression. The Anti-Corruption Commission wishes to inform the general public that the High Court of Sierra Leone, holding in Freetown, presided over by the Honorable Justice Miata M. Samba, has on the 8th of April 2020 convicted Muhammad Sharif, former Managing Director of Sierra Leone Cable Network, SADCAB, and Paul Sandy, former Permanent Secretary of the Ministry of Information and Communication, on 1 count and 3 counts of corruption offences, respectively. Honorable Justice Miata Samba ruled that Mr. Paul Sandy pays a fine of 120 million yuans on all 3 counts, and Mr. Muhammad Sharif is to pay a fine of 60 million yuans on the 1 count. The fines are to be paid immediately before they are released or serve a jail term of 3 years. Mr. Idris Aguilar, on the other hand, was acquitted and discharged. On all 3 counts he was charged. Mr. Paul Sandy, Mr. Muhammad Sharif, and Mr. Idris Aguilar were standing trial for various corruption offences, including misappropriation of public funds, contrary to Section 36, Subsection 1, failure to comply with applicable rules and guidelines relating to the management of public funds, contrary to Section 48, Subsection 2, Paragraph B, and conspiracy to commit a corruption offence, contrary to Section 128, Subsection 1 of the Anti-Corruption Act No. 12 of 2008. The 3 persons were accused of misappropriating public funds amounting to $300,000. On another note, the High Court of Sierra Leone, presided over by Honorable Justice Miata M. Samba, in another judgment acquitted and discharged Ali Badara Mansare, former Commissioner, National Commission for Social Action (NACSA), on 15 counts of various corruption offences. The Commission wishes to reassure the people of Sierra Leone of its relentless commitment in curbing impunity in public service. For FTN's Legal News, Bakarr Marrah reporting. Welcome back to the Legal Hour show here on Freetown Television Network, Channel 35 with me, Bakarr Marrah. Our topic of discussion for this episode is the wall of law. I mean, everything that you need to know about law, you are going to get it today. So be glued as we are actually going to unravel some of these conceptions that you really have been yearning to know about the law. But we all know that this is a pandemic hour, and COVID-19 has actually affected us in different parts of our lives, our economy, our health, our relationships with loved ones. So let us have the new update of COVID-19 in Sierra Leone, which came out on the 8th of June, today, 2020. It came out at around 3 p.m. Cumulative confirmed positive cases, we have 1,001. It has increased. And we have a total number of deaths, we have 49. Active new cases, we have 32. Active cases at isolation centers, we have 341. Cumulative recoveries, we have 611. Number currently in quarantine, we have 1,741. Number discharged from quarantine, we have 5,231. So this is the update of COVID-19 in our country, and we have actually have an increased number of those who are affirmed with coronavirus. So let us stay safe and try to abide by the precautionary measures that have been put in place by those who are medically inclined, and by doing so, I do believe that we can help ourselves to avoid or devoid from contacting the virus. So this is Legal Hour here on Freetown Television Network, and our topic of discussion for this episode is the world of law. Do you really have any interest in law? But this is the world of law. So come join us as we actually unravel the concepts, the juicy aspects of the world of law, as we actually unravel it through my guest, who is Mr. Rashid Dumbuya ESQ, and who is also the Chief Executive Officer of Legal Link. Once more, you are highly welcome, Mr. Rashid Dumbuya.
Thanks for having me.
Yeah, so our topic of discussion for this episode is the world of law. So how do you perceive it to be the world of law as a lawyer?
Okay, well, it will mean several things. The world of law will mean, firstly, looking at law itself, generally speaking, looking at what it's all about, what are the functions of law, the origins of law, the importance of law, looking at how the place of law in society, relevance of law. So there are many facets to that topic, but I'm sure today you are the chairperson, so you will have to let us know which
Yeah.
area of the law we will be focusing on.
All right.
But I'm grateful
So,
and happy to be here.
all right. So basically, when we talk about the world of law, the first perception that actually pop on is that am I a lawyer? And to become a lawyer, what does it take? How can one be motivated or actually get to that particular part and then say, well, I am a lawyer or I will be a lawyer someday?
Okay. To become a lawyer in our country, it is defined. We have a law that tells you the procedures and what you should do in order to become one. And that law we have it in the Legal Practitioners Act of 2000, and its amendments. It has about three or four amendments, and it will tell you clearly that you need to have a law degree. That means you must apply to a University of Sierra Leone, recognized by the under the Act, and of course by the General Legal Council. There's a body that regulates the conduct of lawyers in the country, and or the Council of Legal Education, I mean. So you have to make sure you satisfy all of that, and then you, of course, when you earning your degree, you have to enroll to the law school, and of course, after law school, you get your bar certificate. Afterwards, you have to, if you want to go to the law officers department, you take there like 18 months, do your pupillage, and then you go to a private lawyer. If you want to use that route, it's 1 year, or you must do a pupillage of either 1 year or 1 year 6 months. In the government, it's 1 year 6 months. In the private, under a private firm, it's 1 year. Then after you finish that, you have to also sign a temporary register, and after that is done, also you have to now sign the permanent register, and then that's the time you can now have unlimited access to all the courts in Sierra Leone. And that's the time you can now boastfully say
Okay.
you have been admitted into the legal profession of Sierra Leone. It's a
Yeah,
very long
rule of law.
process, at least about 6 years or so. Um,
Okay.
4 in the university, 1 in law school, and 1 in pupillage.
Okay.
So that's about 6 years.
So
I'm
I
sure.
believe this lengthy process has become one of the reasons people have been saying that it's very difficult to do law. Is it just the reason, or we have many other reasons that you think it's very difficult for people to perceive that to be a lawyer it's gonna be a complex task?
Yes, well, that is the fundamental truth. It's a highly technical discipline, and the time frame, like I said, ranges between 6 to 7 years. So you have to come to an agreement with yourself that this is the time frame I will have to invest in wanting to become a lawyer in Sierra Leone. It's a difficult task, I will argue, because the study itself will demand a lot from you in terms of your time, your research, your reasoning capacity, the way you argue, the way you write out analysis, legal opinions, and the way you come to conclusions. So it's an art a discipline that seeks to train you to be able to argue, persuade, and use your intelligence in reaching conclusions, of law. It's a difficult one. Your analytical skills, your argumentative skills will have to be really, really, really sound, because at the end of the day, it's all about persuading. The law is all about persuading, convincing the bench, convincing your opponent, so that at least he agrees with your view and the bench agrees with your view, and then showing us the law that backs your reasoning, and then the decision is made in your favor. So it will require you to study a lot, read a lot, find the cases, find the law, cite the precedents, and then argue before the bench and persuade your opponents to come to a logical conclusion that will be in your favor. So it's a demanding field of discipline.
Okay. And I believe in our country you've been one of the most famous lawyers as a human rights lawyer. What is it? What actually makes you to be that really famous or so good in your profession? Do you have any secret ingredient that others need to know that they can learn from and be motivated from?
I don't know. they're giving an award, I don't understand.
Of course, yeah, of course, yeah.
I'm one
You're
of the,
so famous, Rashid
I-
Dumbuya, Rashid Dumbuya, everywhere you go.
yeah, well,
We hear the name.
thanks for the compliment, but and I'm humble for all of that. Well, it's not necessarily about name. I've always said people should come to law to impact, your nation and your world. It's not really to come and make name for yourself. It's all about finding your niche, that area of the law where you could best give your potential and serve humanity. So when I realized that I am leaning heavily on human rights law, I quickly, went in for a program and I did a master's in human rights. So it's not about just having the passion. So if you notice that you have a passion for a particular field of law, you must also go beyond the passion to have the knowledge. Alright, that's because that's the danger I've seen in many of our legal practitioners. They have the passion in one area, but they don't want to go for a postgraduate knowledge and training. That's what makes the difference. So when I advocate, I have the passion, but I also know a lot about the issues because I have read human rights law at a master's level and I hold a master's certificate and a degree in human rights. So I have been trained as well. So when you bring the knowledge to the passion, then there will be an ultimate difference in your
So in
advocacy.
other words, you just don't need to have the degree. You need to have a degree, and after it, you have to go further, have more knowledge, and then back it up with a passion.
Yes.
And with that, will give you the actual amount of integrity you're supposed to have as a lawyer within society.
Yes, well, it gives you command of the issues, so you know exactly what you're saying because you are trained and qualified and you are an expert in the field. So what a postgraduate degree gives you, a master's degree, it gives you practical knowledge and expert knowledge in the area. So when you finish your first degree gives you general knowledge.
Okay.
That's why in your first degree you do a lot of subjects. You don't specialize. Yes, but when you go to a master's, that's where you specialize. So you become an expert in that field, and that knowledge will help you with your passion and your work because it will now give you leverage. You understand the issues, and when you talk from an informed point of view. You cite the law, the relevant frameworks, the practical experience. You go beyond just the country's assessment. You look at comparative analysis, international standards, and that's what makes it beautiful because you're now arguing, you're now presenting your case from a global point of view because your mind's eye, your academic horizon has been broadened. When you go to do masters, they broaden your academic horizon to now look at things from a universal lens and not just a national lens.
Okay, and
That's
that
the
makes
beauty
you
about
outstanding in the
Yes,
field.
yes.
Well, wonderful. So if you want to be an outstanding lawyer, you need not just to have the degree locally, but after having the degree, you have to go beyond that degree, have masters and PhD, and then you can be outstanding in the field. So it's not magic, it's just hard work and pursue further. That's all it takes. Basically, of course, most of viewers out there and some of us do have this passion to become lawyers in the future. However, most of those who have this passion, they do not even know what is law per se, where they have this basic idea that law is just some basic rules that guide conduct. So as an outstanding lawyer, how can you actually define or give a description about the word law?
Yeah, well, let me be just simple because we're not really in a law class. But basically, if we have to define law from a layman point of view, it's rules and regulations, that are designed to regulate the orderly conduct and behavior of human beings in society. So where we have a society that is void of laws, like I think it was Socrates or Hobbes that defines what it will look like. It calls it it will be a state where a man will become brutish and nasty. Yes. So that's exactly what will happen in the absence of laws. Man will become brutish and nasty in his actions, and and will become savagery. So laws are there to regulate and to ensure the orderly conduct and affairs of society. So they are just mere rules and regulations.
Okay.
Yeah. So
That are enforced
that are,
by
yes,
the
yes,
recognized
yes,
authority.
exactly.
Okay, so now we have these two different big concepts in the world of law: criminal law and civil law.
Mm.
So how can you demystify between the two, criminal law and civil law?
Yes. So all about the law, can be subsumed into these two uh, um, 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 sources. And I've always these classifications, or rather, this I've always argued that if you want to be a good lawyer, just declassify the law into these two
So,
concepts, criminal and civil law. Because if you go to international, you go to in the regional, you will come back to know that these two classifications are the fundamentals of the law, civil and criminal law. So it's good that you understand what is criminal and what is civil law. So when we talk about criminal law, basically we're talking about that branch of the law that deals with crimes committed against the state. So whenever a crime is committed against the state, then the branch of law that automatically kicks in is criminal law. So it deals with crimes. So and crimes are committed against the state. So when somebody does anything that is criminal, it is not it's not so much against the person or against the victim. It's also against the state. So the state has a duty to come in and arrest, investigate, and prosecute that person. Whether the victim wants that to happen or not is irrelevant because a crime has been committed. For example, armed robbery, mutiny, murder, these are all criminal offenses. Now, on the flip side, when it comes to civil law, we are talking about wrongs committed against individuals, between and among individuals in the state. So wrongs versus crimes. So criminal law deals with crimes, civil law deals with wrongs committed between and among individuals. So that's in this instance, the state is not clearly seen at play. So the choice of going to court, all right, to sue the person is left at your discretion. For example, breach of contract. If somebody employs you and there is a breach of the contract, you can say, okay, then what, let me just leave and go, or I will take action against the person. It's between the two of you, right?
yeah.
So that is lesser, in standard as compared to criminal law.
Criminal law. Now, you were saying about prosecution when it comes to criminal law.
Yes.
And the word prosecution is being used in different ways. So when it comes to the law itself, how can we actually demystify or actually give an objective or how it is being used, or how can one prosecute?
Yes. So in the criminal law, the branch of law that deals with crimes committed against the state, the person or body that brings the action is called the prosecution. So if it's a person, it's the prosecutor. If it's a body of persons, it's called prosecution. And that is the body that is responsible to bring criminal action for and on behalf of the state. So, for example, in the magistrate courts now, you will see a lot of police officers, all right, who bring the case on behalf of the state and the IG. So that is exactly what you can call prosecution. It is a team of prosecutors. Prosecution. If it's one prosecutor, all right. So they have the burden. All right. They have the burden to prove the accused guilt. So in a criminal trial, the person who is alleged to have committed the crime is called accused, and the person who prosecutes is called a prosecutor. If it's another one, it's prosecution. All right. So they will have to ensure that they prove his guilt beyond reasonable doubt. So there's a standard also that must be attained. It's called a standard of proof, and there's the burden of proof. The burden of proof, they rest on the prosecution. They have to take their time, show the evidence, show that indeed it was Mr. A and not Mr. Y that did the murder. It's a burden They have to go beyond themselves, get witnesses, gather evidence, lead witnesses. So it's a whole body. That's why they call it burden of proof. And it is them who must prove the accused. So the accused can even stand there and don't say anything. All right, because they are alleging that the accused has committed the crime. They have the burden to prove, and the standard required that should be met for the burden to be vitiated is called beyond reasonable doubt. Beyond a reasonable doubt.
Wonderful.
So that is a high standard, and many legal analysts have quantified it to be 98, 99% certainty.
Okay.
So there should be no doubt.
But I think that is too lengthy for it to be 98 or 99. Like perhaps can't it be like 75, 80? Because like, it's too lengthy, and somehow it brings some unfairness when someone actually hears about such a particular percentage been looking up to.
Yes, I agree with you. It has been a very critical issue which has led to so many discussions. Why the burden of the standard of proof is so high in a criminal trial and not and lesser in perhaps in civil trials. So, well, this is the argument. Because people will have to die. So in a criminal trial, people can lose their lives. People can be killed. I mean, the accused can be killed if they found them guilty of certain offenses. So, for example, murder. All right. In Sierra Leone, we still kill for 4 offenses. We kill for murder. We kill for aggravated robbery, armed robbery. We kill for mutiny, and we also kill for treason. All right. So, assuming that the accused was charged with one of these offenses, he can lose his life. That is why you don't just reduce the standard and allow anything to go. You have to raise the bar, because somebody's life is at stake. He can be in prison for life. It's a very high punishment. All right. So because of all of this, I'm sure that's why in the classical case of Wilmington and DPP, N35, Lord Sankey had to make that wonderful, decision that throughout the thread of criminal law, it is the prosecution that must prove the accused guilt, and that standard should be nothing else but
I
no
believe
reasonable doubt.
in this particular part, even our law states that our constitution, Act number 691 states, say, and I think in section 23, subsection 4,
Yes.
that a person being accused must be proven innocent until found guilty by a competent court of law.
Yes.
I think it works with that. Okay, so it's like that becomes the presumption of the law.
Yes.
All right. So how can you actually further elaborate on this particular presumption that one is when one is being accused, that person is supposed to be innocent until he can be proven guilty by a competent court of law?
Yes. Okay. Before even I answer that or elicit on that, let me also make some clarifications. So, when Lord Sankey, in that wonderful decision in Wilmington and DPP, made that verdict, many legal scholars have interpreted that to mean, especially when he says proof beyond a reasonable doubt. So it was a difficult moment in those days in England to see that standard being attained. So many people were going scot-free. All right, so they were misinterpreting the whole thing to mean when there is a doubt, set the accused free. But that's what the whole verdict clearly dictates. So what Lord Denning did in his time, Lord Denning was a very radical judge. So in a case Milner and Minister of Pensions, he made it very clear that proof beyond reasonable doubt does not mean proof beyond a shadow of doubt. So he was saying, if even there is a doubt, or there are some doubts, if the evidence still points at him, say for example now, we have the DNA test that says what we saw there belongs to him, but yet we have witnesses who are not too sure of what happened, but the DNA test is there that tells us that what we saw in the girl's vagina comes from the accused. That is enough. So the doubts are there on the witnesses, perhaps their corroboration, but the evidence still points at him. So he was saying proof beyond a reasonable doubt does not mean proof beyond a shadow of doubt. There could be some doubts, But let it be clear that judges should still look for the evidence that points at the accused, and if it's there, they should convict. So many times judges have ignored that, and defense lawyers have utilized that whole thing and started it and caused injustice, miscarriage of justice to happen. So that is the leverage. So as we mention Wilmington and DPP, that sets the standard and the burden of proof on the prosecution, we must also not forget Milner and Minister of Pensions and what Lord Denning said. So as we evaluate the standard, we should also be cautioned that we are not looking for 100%, and proof and certainty. There could be some doubts. Nobody can prove a case 100%. But if the evidence still points at the person, despite the few doubts, the judge must still convict.
Alright, viewers, this is Legal Hour on Freetown Television Network, Channel 35, and our topic of discussion for this episode is the wall of law. And in Nexus on that, I have with me Mr. Rashid Dumbuya ESQ, who is the CEO of Legal Link. Let's go for a short break, and we'll be right back and then continue our discussion. And by going for a break, let's take one of our legal pages for this week. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness.
They say we slept in one world and woke up in another. This global tragedy got humans together despite our social distancing. Our nature is taking a break. And giving us a wake-up call on what and who truly matters. Look around you. Hold on. Breathe. Count your blessings. Take time for self-renewal, for a better start tomorrow. Soon, life will be back. Meanwhile, let's stand apart together, with one heart.
Once you on, once you on, once you on, make you not spread corona. Once I alter, make you not catch corona. Once I with soap, make you not spread corona. Wash up for 20 seconds, make you avoid corona. No sneeze now, you on, make you not catch corona. Cough inside your elbow, not spread corona. Avoid contact, make you not catch corona. When man sick, avoid not spread corona.
This message is powered by AfriCell, because we care.
Thirsty, me feel dry, thirsty. Sierra, where they happy with the ginger. Sierra has a natural new flavor, and it's called ginger juice. It's so amazing, so refreshing. Sierra has a natural new flavor, and it's called ginger juice. Gonna give you stamina. Oh, what a feeling.
Who got the juice?
We got the juice.
Tell me who got the juice?
Sierra got the juice.
Hey, who got the juice?
Hey, we got the juice.
Tell me who got the juice?
Sierra got the juice.
That ginger juice, that ginger. Give me that ginger juice, that ginger. That ginger juice, that ginger. I wanna be in the mood.
Thirsty. Me too dry, thirsty. Sierra, really happy with the ginger. Sierra juice, the taste of Salome.
One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you, and you must know the law. Thus we bring you the Legal Hour. Actors Nemeni Pakait Injuria, the act of the law does no one wrong. But alright, viewers, welcome back to the Legal Hour show here on Freetown Television Network, Channel 35 with me, Bakarr Marrah. And our topic of discussion for this episode is the world of law, and due to that, I have with me Mr. Rashid Dumbuya ESQ, who is the head of Legal Link, and we will also continue our discussion based on the topic, the world of law. But first, let's take our legal page for this week. Newspaper, which came out on the 5th of June 2020. It says ballistic experts implicate Paulo Conte. From the front page, Marrah quickly objected to the evidence in its entirety. The witness also confirmed to the court that Paulo Conte's pistols were in good working order but found foul, indicating that they were not clean since last fired. He said specimens were taken to his department for expert examination assessment and opinion by Detective Inspector Aminata Kamara of the Breaking and Larceny Syndicate Department CID headquarters. The witness police detective Inspector Joseph Abubakar Sanu said the black Glock 17 pistol with registration number SLCIV20 RFEF 234 and the black Glock pistol 21 with registration number SLCIV17 MUX 841 107P and 190x19 mm magazine share a common range of approximately 50 meters. The witness also confirmed that both weapons were made in Austria. He further confirmed that there was no proof mark to show country of origin or export stamp, but from his expert opinion says the Glock 17 pistol is more handy and easier to carry with more precision than the Glock 21 pistol, which according to him is heavier. Meanwhile, the defense counsel J.F. Kamara has pleaded with the judge to direct prison director to relax some detention limitations of the first accused. This is our first story for the legal page. This is the legal page of the legal came out on the 5th of June from the satellite newspaper. Ballistic experts who actually testified witness against Paulo Conte's trial, and it is still going on. And today's episode, our topic of discussion is the world of law, and I have with me Mr. Rashid Dumbuya ESQ, the CEO of Legal Link, and we've talked so much on different concepts about the world of law, and thus we have other relevant concepts that has to be unraveled out by him. So let's have a talk on human rights. Human rights is so famous when it comes to law. Everybody knows about human rights, my rights. So as a human rights lawyer by profession, so what can you say about human rights when it comes to the world of law?
Yes, indeed, human rights, especially in today's world, have attracted a great deal of attention. And you can understand why, because even as we speak, that subject goes to the very existence of our soul and our lives. And everyone has rights. Everyone. As long as you are an individual. In fact, we have moved the debate even to even clients, okay, animals. I talk about animal rights, talk about environmental rights. So the whole concept about human rights is so vital because they are God-given rights. They are rights that accrues to us by virtue of us being human beings. That's what human rights are. So when you are born into this world, automatically you have rights that have accrued to you. The right to life, for example, it comes to you because you are existing in the world. The right to freedom of movement. So they are all intrinsic with our nature itself as human beings, because we want to move. We want to talk, the right to freedom of expression. If you suppress us, our movement and our speech, naturally human beings will react because it contravenes and it's inimical to our human nature as a person. So human rights are fundamental. It goes to the core of our existence. That's why they are so valued, and everyone today is clamoring for their rights. So we as human rights activists, we are so happy because at last the whole world has caught glimpse of the realities of human rights, and nations have to come to that reality because a lot of people will be agitating for their rights, And states should come to the point of understanding that they are doing so because it has an implicit value on their existence. If you don't move, if you don't talk, okay, if you don't have a life, all of this, so what are you, right to life?
So if these rights are so fundamental to our existence, now let's have a limitation in our country, Sierra Leone. So do you think really that these rights in Sierra Leone are so fundamental that the state is supporting it for us?
Yeah, so here's the thing. So because we know how much these rights are fundamental to our survival and existence, it is important that when we pass laws, we take our time to limit those rights. We don't just pass laws that limits them absolutely, that makes it inconvenient and hard for people to enjoy these freedoms and fundamental rights, because it will affect their very life and existence. So states must understand this. So when they come to limit rights, of course rights can be limited, agree, but they must do so in ways that does not fundamentally, affect the survival and the livelihood of the human being. Because if
So
that is the
at
case,
this present moment,
eventually what will happen, there will be an outburst.
okay, so at this moment, do you think that some of these rights that we're supposed to enjoy as fundamental rights are being limited? And if they have been limited, do you think that they have been limited in order that it affects our means of surviving?
Yeah, so here's the thing. So nobody is saying that human rights cannot be limited. Of course, you have some rights that you cannot limit. All right, they are absolute rights. They are non-derogable. For example, the right to freedom of life, right to freedom of torture, the right to life, the right to also not to be treated in humane and in a degrading way, torture. All right, there's also genocide. So nobody can say you can limit and then allow for people to be killed in mass number. So there are rights that cannot, in terms of reasonability. In other words, the limitation must be reasonable. It must not be one that will occasion hardship. So for example, the cleaning day exercise, we have it once, all right, every month. So the test of reasonability. You cannot come and say, I want to have a cleaning day exercise every day throughout the month. That will not meet the test of reasonability.
And also,
The third one, let me just finish this one quickly. The third one is the test of justifiability. So you must also justify, all right, why you are limiting the right. There must be reasons, and those reasons must be convincing, and it must make a lot of sense and appealing to everyone. So for example, now in the COVID environment, we have a pandemic, all right, that haunts lives, that have claimed thousands of lives around the world. So it's a good reason, justified reason, perhaps to limit rights of freedom of movement. And then the last one is the test of necessity. So this is a difficult one. So a state might pass the test of legality, show you the law. For example, now in our constitution, the president has powers to declare a state of emergency and then float out regulations. The test of reasonability, you will say it's okay for from this time it will not. Justifiability, but the necessity test that's very difficult because the question you ask is it necessary for me to limit this right in a democratic society? That's the pitch. So limiting rights is not necessarily bad, but is it necessary? Is it the only option that you have in a democratic society where you expect people to exercise their freedoms and their rights? So that is the question most times states could not pass because the test is high. Sometimes have you explored our options? Do you think this is the only thing you need to do? All right, but remember it's a democracy. Democracy, people are expected to live their life in a freedom way, in a way that does not amount to suppression. So that question is almost always not passed by the limiters of rights because it's difficult, because it's a higher test. Necessity, is it necessary? Sometimes it's not really necessary when you look at it critically. There could have been other options that could have been, explored. So these are the four tests that you must ask anybody who wants to limit your right, including the state. And if they could not pass those tests, then the limitation will be clearly a violation of fundamental human rights.
Of course, yeah. We have more two concepts to talk upon before we actually come to the end of this episode. I want us to talk on this criminal libel act that is actually ongoing to be repealed. So, do you have any notions to actually explicate on this?
Yes, well, the criminal libel law, of course, we have that law with us. The Public Order Act is the legislation. It has been here with us from 1965. So it's we just got our independence, and 4 years later we have this law with us. So, and that law has been widely condemned, by many international and national human rights experts because of the fact that it contains certain provisions that allows for the violation of freedom of the press, for example, also prosecution of human rights defenders, also going after even dissenting views in society, those who express them. So that's the concern, and I believe it is a law that is archaic, and it's time for it to be repealed. And efforts have been made, past and present governments, but yet we have not gotten there as yet. Recently, we learned that it has even been withdrawn back from Parliament, and we are making this call that we need to put all in our powers to have that law repealed. Because as I speak to you, the report of 2019, the World Press Freedom Report, puts our nation in a bad light. It shows that there has been a systematic, attempt to suppress, press freedom in the country, past government and present government. So this is the thing, and we have an IMC. So perhaps why do we need a law that gives the state power to bring criminal actions against people and rights against them or safeties against them? So why not also complain, perhaps even journalists, to the IMC? So we have an IMC, act, and also a framework that gives civil remedies, apology, fines to people who perhaps defame the characters, the press who defame the character of state actors and the like. So why don't we explore the civil defamation route than we go in the criminal way and punishing journalists, especially for expressing their views or commenting on issues that is not in line with state's directives? That is wrong. It is not a law that has a place in a democratic society like.
But however, Section 6 of the Sexual Offences Act of 2019 has been amended, stating that even a child who commits any sexual crime would be guilty of an offense. So it is very much baffled to the legal understanding. So how can you actually help us to at least express it and understand it in that simplistic way?
Yeah, so here is the thing, and these are the things we're talking about. Even if you go further to now, even expatiate, you look at how the Child Rights Act defines a child, and how the Customary Marriage and Divorce Act defines a child. It's sickening. Alright, one is saying 18 and below, and then the other one is saying 16. The Customary Marriage and Divorce Act.
Okay, yeah.
So these are the things. So we see, and of course these two laws you've mentioned, you see how the discrepancy. So that is the point we have to agree that we have a problem in legislation. If we are treating children's issue and we are taking it seriously, then we must have an agreement on the age limit. If we are saying at this age they can be culpable, it must sink down to all the laws. It must be in tandem with all the laws that deals with children in the nation. But we have a law that defines them on one hand, this age. There's another law that says, okay, when they are above 16, they are never considered as a child, and they can be ripe for marriage. What is that? And then we have the Sexual Offences Act that now says, despite him being this age, he can still be held for criminal. Are you understanding what I'm saying? So we have a problem. It's confusing, and that shows that it's bad draftsmanship, because perhaps the draftsmen have not taken cognizance of the other, legislations, that has bearing on children, and perhaps what they say. Because if the parents' law, which I will say here is the Child Rights Act, it's saying that the age of this is what should be this and this should not be, and then we're having other laws coming in as they are, and they are telling us something different, then we are confused. So I will recommend that we go back and look at this legislation, especially that deals with children's rights, and take a position as a state. If we're saying below the age of 18 you are a child, then let's agree that criminal culpability should not vest on children, all right, below that age, when even they do the worst of crimes. But if we are saying again we want to have a paradigm shift, and then we are bringing it to perhaps 14, then all our laws says, well, if you are above 14 and this happens, we can hold you criminally culpable. So we have to make sure our laws are in sync and in tandem
with
together.
2019, the penalty for a child is not less than 5 years, not above 15 good years.
Yes.
And I think it's too much for a child. Perhaps they don't have the requisite mindset to commit certain acts, but if they can be found guilty based on the circumstances around, then they have to be penalized for such length period. I think it's too much for them. That's so for a child, 5 years, not less than 5 years, above 15 good years.
Well, I don't want to go into the severity or non-severity of the penalties. What I am concerned as a human rights expert are the inconsistencies in how our laws bordering on children's rights have created the arguments and problems down the line. Because a good lawyer could look at all of these things and make a strong case. So let's be clear. If we are agreeing that children above 14 but below 18 can be criminally responsible for their actions, then let all the laws that border on children make that clear. And let's have a stagnant age, because we cannot be having one age under the Customary and Marriage Divorce Act, and then we are having another age under the Child Rights Act. It doesn't make for good legislation and draftsmanship, and it's confusing and inconsistent. So my advice would be, perhaps the Children Commission, we have a Children Commission, should look at these issues and form a legal opinion that they will present to the Attorney General and Minister of Justice and his team for proper consolidation and making sure our laws that governs children and their rights are in tandem with each other. That is how we will build upon the legacy and the jurisprudence of children, and their cases in Sierra Leone. Otherwise, I'm afraid we will be abusing their fundamental human rights, and then we should look at what even the international model law is saying. All right, there is the Convention on the Rights of Children. All right, and also there's also an African framework.
African Charter on the Rights and Welfare of Children.
Yes. So these are the things. So we look at the international, the regional, and then we make sure our national laws are in tandem with this regional and global laws.
Thank you very much, viewers. I have with me in the studio Mr. Rashid Dumbuya ESQ, the CEO of Legal Link, and our topic of discussion has been the world of law, and through that we have learned a lot from him about how we can be a good lawyer, how we can be motivated, and how we can actually stand and make a difference in the world of law. Well, this is Legal Hour once more, and if you happen to miss any of our discussion, you can rejoin us in our Facebook page Legal Hour, or visit our page on YouTube Legal Hour FTN. And I have been your presenter, Bakarr. But before we close, let's have the final words of our guest, and it's been an honor to have you in my studio. So what could be your last statement to viewers out there?
So if you're out there and you like law and you want to be a lawyer, two advice I have for you. One, pursue it, but most of all, don't come to read law or pursue that career with an ambition to have wealth. Let your primary motive be to impact lives, to fight against injustice, and to develop your nation's criminal justice system. If that is the goal, I bet you will succeed, and then you will be a comfortable lawyer. I won't say you'll be a rich lawyer, but you'll be comfortable and you'll be admired. Because what is important in life is about fulfillment, impacting your world, making a difference, and your life will be fulfilled.
Thank you very much. I believe I'm almost, of course, I'm motivated by those words. Thank you very much. And I also hope to have you in my subsequent programs as time goes on.
Always.
Well, if you are, this is how we come to the end of today's episode. It's been a pleasure for being your presenter. So we'll meet again for next episode. Goodbye. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the legal hour. Actus nemini facit injuria, the act of the law does no one wrong, but uphold justice. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the legal hour. Actus nemini facit injuria, the act of the law does no one wrong, but uphold justice.